Under California law, some life sentences are eligible for parole, and a parole board rejection of an application does not preclude a different decision in the future. Susan Atkins and Patricia Krenwinkel, who were originally convicted along with Van Houten and Manson at the main trial, had both been found guilty of the most notorious crime, the murder of 5 people at 10,050 Cielo Drive. In addition, Krenwinkel was also convicted of the murders of Leno and Rosemary LaBianca, while Atkins was also convicted of murdering Gary Hinman. Only one other member of the Manson family has been convicted of murder and later released. Steve Clem Grogan, convicted and given a death sentence by the jury for the torture murder of Donald Shea with Manson, was freed in 1985. Bruce M. Davis, also an accomplice of Manson in the killing of Shea, and with a second conviction for the Gary Hinman killing, was given a parole board recommendation for release in 2010, although very few inmates with even a single conviction on a charge of murder had been able to obtain parole in California before 2011. In each case, the sitting governor ordered a review or reversed the decision. Tex Watson was denied parole for the 15th time on October 27, 2016. After receiving her 13th rejection, in which the hearing concluded she posed an unreasonable risk of danger to society. Van Houten took legal action. Judge Bob Krug ordered the board to rehear the application because their reasoning turned solely on the unalterable gravity of her offense and effectively gave her life without parole, a sentence unauthorized by law. The judgment was overturned by a higher court, which said although parole hearings must consider evidence for an inmate being rehabilitated, a hearing had discretion to deny parole based solely on a review of the circumstances of the crime, if some evidence supported their decision. In 2013, Van Houten was denied parole for the 20th time at a hearing. In announcing a decision to deny parole, the commissioner of the hearing board said that she had failed to explain how someone of her good background and intelligence could have committed such cruel and atrocious murders. On April 14, 2016, a 2-person panel of the California Parole Board recommended granting Van Houten's parole request. But California Governor Jerry Brown vetoed the release on the grounds that both her role in these extraordinarily brutal crimes and her inability to explain her willing participation in such horrific violence cannot be overlooked and lead me to believe she remains an unacceptable risk to society if released. On September 29, 2016, Los Angeles County Superior Court Judge William C. Ryan issued an 18-page ruling upholding the governor's reversal earlier in the year of a parole board's decision to release Van Houten. Ryan wrote that there was some evidence that Van Houten presents an unreasonable threat to society. On December 21, the California Supreme Court denied Van Houten's petition to hear the case. Van Houten has long since renounced Manson, who died in prison in November 2017. She has expressed remorse for her crimes, and at her 2013 parole hearing, her attorney argued that her value system was completely different from what it was in 1972. She expressed that she takes offense to the fact that Manson doesn't own up to his role in the murders. She told Vincent Bugliosi, the man who sent her to prison, "I take responsibility for my part. And part of my responsibility was helping to create him." She has written several short stories, once edited the prison newspaper and did some secretarial work at the prison. Van Houten was again recommended for parole at her 21st parole hearing on September 6, 2017. The 2-member panel found that Van Houten had radically changed her life in the more than 40 years she had been incarcerated. Governor Jerry Brown again denied her parole on January 19, 2018. Her legal team stated they would fight the decision. On June 29, 2018, Van Houten's parole was once again vetoed. The judge was again William C. Ryan, who said, unless the inmate can demonstrate that there is no evidence to support the governor's conclusion that the inmate is a current danger to public safety, the petition fails to state a prima facie case for relief and may be summarily denied. On January 30, 2019, during her 22nd parole hearing, Van Houten was recommended for parole for the third time. But on June 4, 2019, Governor Gavin Newsom overruled the parole board's recommendation, claiming the then 69-year-old Van Houten was still a danger to society, and that she had potential for future violence. She appealed the governor's decision. But on September 21, 2019, the appeals court panel ruled 2-1 in the governor's favor. Van Houten was recommended for parole for the fourth time at a 23rd parole hearing on July 23, 2020, and a 120-day legal review period began. On November 28, Governor Newsom again rejected the board's recommendation and vetoed Van Houten's parole. Among his reasons for denial, Newsom stated the then 71-year-old Van Houten currently poses an unreasonable danger to society if released from prison. Again, her lawyer, Rich Pfeiffer, said they would appeal the governor's latest decision. On November 9, 2021, Van Houten was recommended for parole by a parole board. On March 29, 2022, Governor Newsom overruled the parole board's recommendation. Her request for review was rejected by the California Supreme Court on February 9, 2022. On May 30, 2023, a California Court of Appeal in Los Angeles set aside Governor Newsom's denial of Van Houten's parole, thus becoming the first Manson family member to have a court rule in her favor for a parole recommendation. On July 7, 2023, Governor Newsom announced that he would not appeal the California Supreme Court to block her parole, paving the way for her release. Van Houten was released on parole on July 11, 2023.